Hi, everyone. Happy Tuesday. Welcome to our weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and I'm happy to be with all of you here today. I know we have a lot of individuals watching live. And so for those of you who are our regulars, you know the drill. I love to ask, where are you at in the world? If you can throw that in the comments, let me know, where are you at in the world and where are you at currently in your immigration process? Are you just starting out? Are you in the middle of your journey? And for those of you who are new, welcome. It's great to have our regulars, but it's also really great to see new names and new faces. So welcome. Immigration for Couples, our firm is dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. And we know here at Immigration for Couples, knowledge is power. And it can be very overwhelming when you are just starting out and also in the middle of your immigration journey. The immigration process is a labyrinth. It's bureaucratic and it's just, like I said, a labyrinth, right? And so we created a free resource center. So if you go to our website, immigrationforcouples.com, and I'll throw that link in the comments as well, we have a very robust free resource center. I have a free relationship evidence guide, and I also created a webinar that I really encourage you to check out if you're just starting out in your immigration journey. In the webinar, I really dive into what are the different options that are available to couples, how do you prove your relationship, and how do you not just survive but thrive in the immigration process. And again, I am streaming this live on Facebook, LinkedIn, YouTube, and Instagram. And so I have a couple screens here going, and if you ask me questions, I will answer them in the order that I receive them. So I know I have some individuals who already had some questions queued up. And so I will also keep an eye on our Facebook and Instagram questions as well. So let's start though with anybody I ask, where are you at in the world and where are you at in the process? So Andrea, you're in Berlin and you said you're just getting started. So this is a great place to be. Welcome. We're really happy to have you here. Ginger, it's so lovely to see you. I know you're in the UK right now. Just came back from you said in the previous sessions you've joined with us that you had a nice trip with your fiance. So, and then hi, Jose. It's great to see you again. And you're still waiting for the I-130 petition. I know that you said you felt a little disheartened and you have come every week letting us know, and we're all rooting for you and hoping you get an approval soon. It's great to have you with us again. Yes, Merry Christmas in advance to you as well. Happy holidays to everyone. Sam in New York, great to have you with us. And let's see who else we have here. Where else? Oh, this is awesome. Good morning to everyone watching from around the world. And you are in Jacksonville, Florida. Awesome. And Betty, you're in Canada. So, all right. So let's go ahead and get started with the questions I have here in the queue. Okay. So the very first question I have is regarding a petition. So let's see, you said, can your husband's cousin co-sign for my marriage visa petition if my husband's income is low? So this is a question about the affidavit of support. My husband's income is low to sponsor me, but his cousin, okay. So the question is about joint sponsorship is what I'm hearing. And you're wanting to know if a family member can be a joint sponsor. So I always like to back up. For those of you who aren't at this step yet or just starting out, you're probably like, wait, there's an income requirement, or what is this affidavit of support? So when you're going through a marriage green card process and a fiance visa process included, in order to receive the green card, you have to have the petitioner, rather, the U.S. citizen or lawful permanent resident, has to prove that they have sufficient income to support you in order for you to receive a green card. Or in the reverse, if you're a petitioner, you have to prove you have enough income to support your future spouse or your current spouse if you're already married and going through a spouse visa process. The way that immigration determines whether or not you have enough income or enough financial resources to support your spouse is through your tax return. So immigration is going to look at your most recent tax return at that total income line and determine whether or not you make enough based on that total income line in comparison to what they call the poverty guideline. So the poverty guideline is going to depend on your household size. So if you as the petitioner have dependent children or have other dependents that are included in your tax return, that will impact your household size and how much you have to make. So that's the first step. And then from there, if you don't make enough, then an option is that you have what's called a joint sponsor. So a joint sponsor can be anyone who is a friend or a family member who is a lawful permanent resident or US citizen who is able to step in place and in that place and be the financial sponsor. So the financial sponsor has to sign something called an affidavit of support. And this affidavit of support is really a contract with immigration saying that you agree to be the financial sponsor, the financial backer, if this individual is unable to support him or herself. So the answer is yes, it is possible that your husband's cousin could be a joint sponsor as long as your husband's cousin makes enough. So each sponsor, a joint sponsor, is going to be held to the same requirements as the US citizen petitioner. And so that tax return is going to come into play. You would have to have that 2023 tax return. The joint sponsor has to have that because that is what immigration is looking at to determine whether or not the person has enough income. So great question. And I think that was probably very informative for others, especially who are just starting out, to understand that as a requirement in the process. Okay, so if your wife is coming from overseas during the process of marriage visa petition, are you going to be with them in a foreign country interview once you are hired? Okay, so I think what you're asking is, does the US embassy or consulate allow an attorney to go to that interview at that US embassy or consulate? And so part of the spouse and the fiance visa process involves an interview abroad at a US embassy or consulate abroad, typically in the country where the individual is living. At that interview, US embassies and consulates have very strict requirements about who is allowed to enter that interview. Typically, most US embassies or consulates are only going to allow the person who has an interview. So that immigrant beneficiary is typically the only individual that they will allow to enter the building. In some cases, US citizen petitioners are able to go if they ask for permission in advance. But I will tell you, there's a lot of US embassies or consulates that say, no, no one else can attend. That includes attorneys. No one else is able to enter that US embassy or consulate interview. It has to be the person who has the interview that day. They do that for security reasons, and they do that for capacity reasons. They just don't have, a lot of the embassies and consulates don't have enough space, but it's a matter of space and security. There are some situations where an interpreter might be needed, and that has to get pre-approval. And other situations we've had where we get a pre-approval for another family member to go is if the person needs assistance for a medical reason. However, here at my firm, I think the other part of your question, that this will answer the other part of your question. Here at my firm, before that interview happens, we have an interview prep session with our clients, letting them know what they should take, what they should expect. And then we do a mock interview as well, going through basically a pretend interview where I ask questions and pretend to be the officer so my client can get a feel for what's going to happen at the interview before it happens. So you can be very confident walking into that interview. All right, let's see what questions we have next. So Annette, you're asking about the fiance visa process, and you're wanting to know about red flags. So, and then you're also wanting to know, okay, so you have two questions. So you're wanting to know about red flags. So for those of you who are just starting out or maybe have not heard of red flags in the immigration process, USCIS immigration has an adjudicator's manual, which is the manual, the policy, the guidelines that immigration officers use in making decisions on cases. And in that manual, there's a very long list of red flags. And in those red flags, adjudicators are trained to look for these red flags and decide whether or not, these red flags are present and if this relationship is real, because it's the officer's job to determine, based on the evidence provided, is this a real relationship based on love and not just to receive an immigration benefit. So you're asking about whether or not a same-sex couple is going to be a red flag. So that's not on the red flag list. Same-sex couples are supposed to be treated the same in the immigration process and held to the same standard, and their cases adjudicated in a similar manner. Red flags, though, to give you some ideas of what red flags are in that adjudicator's manual, a significant age difference is one. If there were prior immigration applications that were filed, so if you both filed an application before and it was denied, or if you filed for someone else previously and it was denied or approved, if there were prior petitions at all. If there were prior marriages, so if either of you have been married before, and then if there's a recent divorce. So that red flag list is very long, but that's a few examples of what you'll find on the list. And then in terms of being able to apply for a fiance visa and another type of visa like a J1 visa, you have to be very careful. There are immigrant visas and there are non-immigrant visas. Immigrant visas are for individuals who have what's called immigrant intent, that you have the intent to come immigrate to the United States and live. Non-immigrant intent is I have an intent to just come for a short period of time. A good example is a tourist visa. So a tourist visa, you are coming for the limited purpose of tourism, of travel, of visiting. So when you are telling immigration through your immigrant intent option, like a fiance visa or spouse visa, you're telling immigration, and actually you have to prove to immigration it is your intention to come here and live with your spouse and have a life. And then if you're applying for another visa, like a tourist visa, where immigrant intent isn't allowed. If you were to apply for a tourist visa and say, I'd like this visa so I can go and live in the US, that's not allowed. That's not what the tourist visa is for, and you'd be denied. So you have to be very careful if you have, if you're going to apply for two different immigration options, you need to make sure that it is legally permissible and that you're not sending contradictory information into your immigration history and file that's going to cause you issues in the future. In general, if you're going to be applying for the fiance visa, it's not going to be legally permissible to apply for a J visa as well. Please understand, with these types of questions, it is really important that, or with that type of question in particular, it's going to be very case specific. And so you need to have a consultation with an immigration attorney in private where you can get specific legal advice as to whether or not that's going to be legally permissible or safe in your situation. All right, so let's see, who do I have next? Okay, so Tucson, Arizona. You're sharing great news. That's so exciting. So last Tuesday, your fiance had his interview and he got approved. Congratulations. We're all celebrating you. So you started the process in March and you're very happy that you'll be together soon. So are we. That's great. Congratulations. Here you go. And you have someone else that's also letting you know that they're sending you congratulations. So that's great. Okay, so you're wanting to know about the wait time after submitting documents to the NVC. The NVC is the SEAC portal. If you're going through that right now, you'll know that it's very glitchy and it's not cooperating. But once you do get all of your documents submitted and uploaded to the portal, then as long as you have everything that's required, we have seen cases become documentarily qualified in some cases in a matter of days, and others it might take a few weeks depending on the specifics. After you are documentarily qualified, and for those of you who don't know what that is yet, when you go through a spouse visa process, one of the steps in the process is uploading documentation to the National Visa Center. Based on your particular case, those requirements will be different. But once you upload those documents, in immigration sees that you have everything that's required, they will give you a notice that says you are documentarily qualified. And that's a fancy way of saying you have all the documents on the list and we can put you in line for an interview. And then interview wait times are going to vary widely based on where your interview will actually occur. All right. Let me check here on our Facebook questions. For some reason, some of my questions don't come through in order. And so I want to make sure I'm not skipping anyone here that might be watching on Facebook. Okay. So, hi, Joe. It's great to have you with us. So you're in Chicago. and your future bride is coming to the USA next week on her fiance visa. That's great. Congratulations, right in time for all the holidays. That's fantastic. And does she need to check in with an immigration office when she gets here? So when someone enters on a fiance visa, when you enter the United States, you're getting into the final stages of that process. And it's also the one of the very most important stages of the process after entry on a fiance visa, because once you enter on a fiance visa, you have 90 days to get married. That's where the whole 90-day fiance visa TV show, how they got their titles, because you have 90 days to get married. And then you also need to file for adjustment of status for the green card. And so that is essentially how you're going to check in with immigration, is that you need to be in compliance with those requirements. And so, Joe, I encourage you to check out our free resource center. And if you need help with your adjustment, don't hesitate to reach out. You can schedule a call with me, a phone or Zoom call on the website 24/7, and I'd be happy to speak with you in private if you need more guidance. All right. Let's see if I had anybody else that I missed on Facebook. Okay, so John, you're wanting to know the right amount of information to provide when telling the circumstances of the in-person meeting requirement. So I know there's a lot of rumors. That's the word I'm looking for. Rumors out there on the internet that you have to provide this very long statement of how you met and when you met, and your relationship history. Typically, I don't have clients do that. Typically, it's you are going to be providing the story of your love through evidence. That's what immigration is wanting to see. And so I would encourage you, John, to check out our free relationship evidence guide. So, because I think you're asking, should you like write a 1, 2, or 3 page statement? So while it's nice to, share your story of love with immigration in writing, the stronger way to prove your relationship is through relationship evidence. And so in that relationship evidence guide, I talk about the different categories of evidence. Immigration is wanting to see that you've met in person. So things like plane tickets, passport stamps, photos that have time and location stamps on them, things that show and demonstrate that you've been, physically in person for that requirement if you're doing the fiance visa. And then other categories of evidence, there are the commingling of finances. For couples who might not be living together yet, you might not have as much in that category, but it is something that as you progress in your case and you do get to the point of living together, that immigration will want to see commingling of finances. So that's things like having a joint bank account and filing a joint tax return. And then there's the category that I have coined lovey-dovey evidence. It's not a legal term, but that's the photos, right? Photos, letters of support from friends and family, gifts and cards that you have exchanged. Those categories of evidence are really what immigration is looking for in your application, proving that your relationship is real. In terms of writing a statement that you're going to submit to immigration, you have to be very careful with that, because I have had individuals who have tried to pro se or represent themselves on their own. And while you know your story of love, you may unwittingly or unintentionally provide so many details, and that there could be information that's contradictory. Again, you might do that unintentionally, and it can also make the interview process more onerous for the immigrant beneficiary when that time comes. So just be very careful with statements. I have definitely seen that go well and go very, 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 very wrong for individuals. So I would really stick to those the main categories of evidence to prove your relationship. And please do check out that relationship evidence guide. Okay, I want to make sure. Okay, so Joe, you gave me an okay that you got it. Yay, Sean, it's great to have you here. Excited to see that our case is progressing. Hoping to chat with you soon, but if not before Christmas, wanted to wish you happy holidays. Oh, happy holidays to both of you as well. Congratulations, super stoked. All right, and you're very welcome, John. And again, I'm the phone number and the website are below. I'm always happy to speak with you in private, any of you in private, if you'd like to make a consultation with me. All right, and let me check on my folks on Instagram here. I see we have some individuals who've joined us. And so some have just joined us. I see some individuals saying that they're stressed about the I-130 wait time. that you're in at your, sorry, goodness, my words today. Yeah, my mind is going quickly while I'm reading your question. It says, I am Lebanese and my husband is a green card holder. We're getting married in February of 2024 and submitted the I-130 form. I'm frustrated about the waiting time and afraid of being denied. Yeah, I understand. The wait times have really expanded for the I-130 petition. We're seeing that most cases are taking more than a year to have the petition approved. I know that's disheartening, but if you can really focus on your mindset, especially with you filing in February, think about it being one day closer. I know from personal experience, having gone through the process with my husband, we experienced, long waits, glitches with the NVC, all of that. I completely understand, but just really focusing on the progress you've made instead of focusing on how much is left. Knowing that you're a day closer, celebrate that you have that petition filed, you are getting closer, and then focus on what you can control, which is proaction. We're really big here at Immigration for Couples, practicing proaction, working ahead, getting the documents that are needed for the next steps, and having all of that ready so when the petition is approved, you can hit the ground running and keep things moving for your lives. All right, let's see who else we have here in the queue. Okay, so this one is a two-part. Oh, this one is an interesting, Kimberly. So you said, good morning from Maine. Good morning to you too. Your lawyer recently notified the senator's office in your state to get your case moving along. Does this really help with the process? A 22-month wait is very long. I don't know if you have already received an approved petition, but waiting to get a decision on the petition for 22 months is extremely long. That's outside of normal processing times. There are situations, if there are complexities in your case, that it could cause that, but not 22 months. But if you already have the petition approved and you're in the stages of interview and interview scheduling, depending on what U.S. embassy or consulate that the interview will occur, sometimes that can cause longer wait times for an interview. Nigeria, for example, in Lagos, it's a very long wait to receive an interview. So it is possible to with the combination of waiting for the petition approval and then the interview, it could expand, into that kind of waiting time. But if you're talking about just the petition, that does seem abnormal. And in terms of your question of the senator's office and congressional representatives, it's important to know that what the role is of senators' offices when you're doing a congressional inquiry. What is their role? So their role is not to force immigration to do anything. Their role is not to encourage immigration to approve your case. That is not their role and not what they're legally allowed to do. What congressional inquiries can do is facilitate communication, an open line of communication between you and immigration. Because if any of you have tried calling the immigration 800 number, you know that getting past the robot is extremely difficult, and then getting information and just getting someone to hear you and listen to you and pay attention to your case, that's half the battle. And so in that regard, a senator's office or a congressional inquiry can help with liaison efforts, can help with communication efforts to give you some clarity. However, it's important to understand that even making those inquiries, the senator's office might also get a cookie cutter response. But I'm glad you have an immigration attorney, and I really hope that you get a decision soon, because that's a long wait. We're all sending you prayers and positive vibes for a decision soon. Let's see. This one's a two-part question here. You're very welcome. With public charge, does a petitioner's current unemployed status when filing a K-1 have a negative impact? And that you are seeking employment. There's a co-sponsor available for the affidavit of support, but since this info is provided for consular interview stage, is it possible to make it known with application 2 to be safer? Thank you. So with the fiance visa process, you have basically an initial affidavit of support through that form I-134, and then you'll have another affidavit of support at the green card phase. So what they're looking at is that your current income. So they're going to be looking at your most recent year's tax returns plus your current employment information. And you did the right thing. If you don't currently have a job, or if your income doesn't meet the requirements, then like you said, you have a joint sponsor. That's great. If by the time you get to the green card phase and you get to the phase of needing to file the affidavit of support with the green card phase of the case, if at that time you make enough, then you could move forward with just your income and not a joint sponsor. Your question about like, can you clarify that for the consular post? I mean, you can. It's not going to make a difference to them. They care. What they care is whether or not you make enough, and if you don't, that you have a joint sponsor. And then there'll be, like I said, future steps with the marriage green card that you'll have to update that information. And if you're making enough at that time, then you could use your income alone. Okay. I'm not sure if I understand your question here. So your question is, when filing time begin, do I apply for my fiance or after immigration receives the documents they ask for? I'm not sure if you have another part to your question. So I'm not sure if I'm clear on your question. I think you're asking, when you're filing, like, do you provide the documents at that time? Yes, when you're filing your petition, when you're filing a fiance visa or spouse visa case or your green card application, you have to provide the evidence at that time. If you do not include all of the required evidence, then immigration will either reject your case, they'll just send it right back to you, and they won't give you a receipt notice, they won't accept the filing. In other cases, if you don't provide all the required documents, they might accept your case, and then later, if you don't have everything, they'll send you a request for evidence or a notice of intent to deny. And ideally, you want to avoid those notices. Sometimes a request for evidence is expected. Like in a new tax year, everyone will get a request for evidence for updated tax returns. But you, in large part, want to file a very strong case and avoid that, because you don't want to be in a position of having a request for evidence or a notice of intent to deny, because that's usually going to be an uphill battle. So yes, the answer is yes, you have to include all required documentation. All right. We are here. We're getting close to time here. I'm going to see if I can grab one more question. And hello to you as well. Great to have you with us. Okay, so I'm going to grab this question here. Your partner, because this is a question I really answer almost every show, because the rumors out there online are rampant, and I always want to clarify this, because it's super important to know that what the immigration laws are and what they don't permit, so you can avoid falling into a really big issue. So your partner is coming on ESTA, and you're wanting to get married when he visits. Would we just do an adjustment of status? So the answer is, you cannot enter on an ESTA or a tourist visa with the intention to get married and file for adjustment of status. That's not legally permissible. Can you come on ESTA and can you get married and then leave before your 90 days of permitted time in the US on ESTA and then start a spouse visa process? Yes, that is possible. But immigration laws regarding adjustment of status do not allow you to come with that intention. Why? Because earlier in the show, if you weren't here when we first started, I talked about immigrant and non-immigrant intent. So immigrant intent is when you have the intention that you want to come and live in the United States. That is your intention. You would apply for a spouse visa, for example. That visa is immigrant intent. You have to prove that that is your intention to live in the US. ESTA, or a tourist visa, for example, that is non-immigrant intent. ESTA and a tourist visa allow you to come for a short visit with the purpose of just that visit, that you're coming short period of time and leaving. It does not allow you to come with the intention of having that immigrant intent. You cannot come with the intention of staying, living in the United States and not leaving. So please don't do that. Please do talk with an immigration attorney, especially, when you're just starting out and you're understanding your options, because it breaks my heart when I see couples read things online about what they can and what they can do. And I know online there's a lot of places that say, if you have ESTA or a tourist visa, come and get married and adjust status, that's faster. But please don't do that, because I've had, sadly, couples who've come to me after doing that and they have a mess on their hands. That immigration officer, reviewed their case, called them in for an interview and said, hey, you broke the immigration laws. This is fraud and misrepresentation. You can't do this. And then they're in a really complex, really sticky situation. I don't want that for you. I don't want that for anyone. So please, I'd be happy to speak with you on a private call. We can talk on Zoom or on phone, and we can talk about what options make the most sense for you both, especially before you get married. That's a really good time. Educate yourself, understand your options, so you can take the best next steps for your relationship and for your life, to meet your goals. All right. Well, it's great. Great being with all of you here today. I will take a look at all of the other questions that I received. And I always make, videos. So if you check out our free resource center, that's below, immigrationforcouples.com. The resource center is very robust. And again, I would really encourage you to check out the webinar. So if you're just starting out, like Chantel, you're talking about getting married on ESTA and options, you're very, very welcome. If you check out that webinar, I go through all of the options that are available, how to prove your relationship, but that's a really great place to start. And then also, like I said, I'll look at everybody's questions that I wasn't able to get to here today. And that's really the ideas or the questions you have is really what gives me content, so I can make videos for all of you to answer your questions and help you through the process. All right. It was great being with everyone. Happy holidays. I hope you have an amazing holiday season. Next Tuesday, I will not be doing a live event because I will be spending time with family. But we will be back the following week on a different day. So just stay tuned for that announcement for our next live. And then after the new year, we'll be back on track with our Tuesdays at 11 a.m. Eastern time. Again, happy holidays. It's great seeing all of you. Take care. Bye.